court as opposed to substantive bankruptcy law. Before we get into the structural changes, however, a couple of background points from what we addressed last time. First of all, remember that until early 1970s, bankruptcy cases were largely heard by referees in bankruptcy. They were called referees because bankruptcy matters were referred to them by district judges. Secondly, those referees were appointed for a term of years by district judges. Just last week, I asked Judge Nielsen how that actually worked here in Arizona, because you can think of a couple of ways. Maybe the district court gets together and votes and so forth, and I was wondering, or maybe it's a perk of the chief judge of the district court. Judge Nielsen told me no, they traded off. They took turns. So when an appointment came up, some particular district judge, it was his turn. So he got to make the appointment. So in fact, Judge Nielsen was appointed by Judge Mickey. He was just called into his office one day and told he was going to be appointed as a bankruptcy judge, even though he hadn't really done any bankruptcy before then. He was in the U.S. Attorney's Office, primarily representing the IRS. So that's the way it was done, and that is kind of important because you can kind of see how, from the district judge's perspective, the referees, a lot like their own bankruptcy clerks, because they were an individual judge's appointment. One of the big objections to that whole process was that that referee then hears a matter and you appeal. To whom do you appeal? Probably the same district judge who appointed the referee. Raised a lot of questions about whether you're really getting an independent review on your appeal when you're appealing the decision of a person the judge appointed for that job. And secondly, until the bankruptcy code, bankruptcy courts could only hear disputes related to property in their actual or constructive possession. In other words, bankruptcy courts had jurisdiction over property of the estate. They could hear claims that creditors made to property of the estate, or a claim against the debtor, and they could hear the debtor's right to a discharge. But as to the debtor's causes of action, whether they're contract or tort, I mean, the debtor just has a receivable that he's got to sue somebody on to collect. That collection action could not be brought in the bankruptcy court. That was part of what was called plenary jurisdiction, not summary jurisdiction. And for plenary jurisdiction, the defendant had to agree, again, either actual agreement or constructive agreement, implied consent, to have the bankruptcy court hear it. And that applied not only to debtor causes of action, ones that existed before the bankruptcy was filed, contract actions, tort actions, but also the bankruptcy causes of action that you're familiar with, fraudulent transfers and preferences. Those also could not be brought in the bankruptcy court unless the defendant consented. So if you have a trustee who's filing a slew of preference actions, he's going to have to go to other courts where he can get jurisdiction over the defendant and file the actions there and pursue them there. Obviously, maybe many other courts. Extremely cumbersome, of course, for trustees. Well, that's the status as of the time the bankruptcy code was considered. Now let's back up a little bit and start addressing what changes it made primarily on the structure of the bankruptcy court itself. First of all, the Bankruptcy Commission was appointed by Congress in 1970 to study bankruptcy law and propose reforms. As originally drafted, the bill creating the commission said that the president would have appointees to the commission, the two houses of Congress would have appointees, and the Chief Justice would have appointees, but the bill specified that the Chief Justice's appointees should be active sitting referees in bankruptcy. That provision was objected to by the chair of the Judicial Conference's Bankruptcy Committee. You should all have a handout, and I gave you some terms of art. The Judicial Conference is the policy-making body of the United States judiciary. It's headed by the Chief Justice. They have, among various committees, a bankruptcy committee. The members, as you can see from the handout of the Judicial Conference, are all sitting district judges. No bankruptcy judges had any role in the Judicial Conference. They were not even members of its committees. In any event, the chair of the Judicial Conference's Bankruptcy Committee, Judge Weinfeld, opposed that requirement of designating bankruptcy referees to sit on the commission. So it was ultimately not included in the bill, although Senator Burdick, who had introduced the bill, had specifically made clear that it was Congress's intent that the judiciary's appointees to the commission be bankruptcy referees. That, however, was ignored. The Chief Justice ultimately appointed 2 district judges, one of them being Judge Weinfeld and the other Herbert Will of Illinois. So the commission went to work. In 1973, proposed its bankruptcy reform. As I mentioned last time, they had a 2-part report. Part 1 was a report, like commissions always do. What are the problems? What are the solutions? But then Part 2 was an actual bankruptcy code. They drafted the entire code, including jurisdiction of the court and so forth. Its proposed bill or code would have independent bankruptcy courts, truly independent courts with judges, but the judges would be appointed by the president, not by the district judges who appointed referees, confirmed by the Senate for 15-year terms. However, most issues would be addressed by a bankruptcy administration, an executive branch agency, much like the Internal Revenue Service, right? You have a dispute over your taxes, you first address it with the Internal Revenue Service before filing a lawsuit. Or if you have a claim for Social Security benefits, you go to the Social Security Department, make your claim. They rule on it. Then if you have a dispute, you can sue. But the commission's bankruptcy bill was essentially of that structure, mostly handled in an executive branch administrative agency. The commission's bill was introduced in Congress in October of 1973, but as all of you who were around then can remember, Congress was not paying any attention to bankruptcy at that time. It was consumed by Watergate hearings. So nothing happened immediately on that bill. The bankruptcy referees, although they liked many aspects of the commission's bill, one thing, and especially the independent court, and the fact that they would be real judges, not referees, one thing they didn't like was presidential appointment. Why? Because that would politicize the process. In their view, you'd get political hacks appointed to this job rather than experts in the field. So one of the primary objections of bankruptcy referees was presidential appointment. They also were displeased with the commission's report and bill because the whole commission was entirely composed of, to the extent they had any experience in bankruptcy, was all business reorganization. There was no representative of either the consumer or the debtor side of consumer bankruptcy on the commission. And consequently, its bill paid almost no attention to consumer bankruptcies, even though that, of course, was the bulk of the work of the bankruptcy courts. Bankruptcy referee Joe Lee wrote directly to Judge Weinfeld, who is both the chair of the Judicial Conference's Bankruptcy Committee and a member of the commission, asking for a meeting so the referees could discuss with the commission or the Judicial Conference the administrative structure proposed under that bill. The response he got was, I don't see that any purpose would be served by such a meeting. The commission's bill is what it is. It's being introduced in Congress. It went on and said, so if you have any concerns about it, address them to Congress. Turned out to be perhaps an offhand intended as a blow-off comment, but it had a lot more significance as history evolved. So one thing the National Conference of Referees in Bankruptcy decided to do was draft its own bill. It went to work and drafted a bill very quickly, and that bill was introduced in Congress simultaneously with the Commission's bill in November 1973. The Judge's bill, and I'll address that in a moment, provided for the bankruptcy judges to be appointed by the courts of appeals, hopefully to remove them from the political process of presidential appointments. Also for 15-year terms. Wholly other issue going on purely by chance, and that is, for the first time, there are bankruptcy rules being adopted. There had never been bankruptcy rules before. All federal rules are drafted and adopted by the Judicial Conference of the United States, which has a rules committee for that purpose. That's where your federal rules of civil procedure come from. They're subject to veto by Congress, but ultimately, Congress never pays any attention to the rules. The Judicial Conference drafts them. There hadn't been any special rules for bankruptcy courts up until this time, but also in the fall of 1973, the Judicial Conference proposes the first set of bankruptcy rules. It included in Rule 901, which was the definition section, a definition of bankruptcy judge. It was probably purely for drafting convenience. It defined the bankruptcy judge as being the referee or the district judge who is hearing a particular case or dispute. And it was just for drafting ease in the rules so that you could then refer to the bankruptcy judge, whichever of them is hearing it. Nonetheless, the referees in bankruptcy took this new set of rules, which was, as I said, coincidentally adopted in September of 1973, as making them all judges. We're not referees anymore. We're judges. We're defined as judges in the rules promulgated by the same Judicial Conference that never wanted us to have any part in bankruptcy legislation. So they started calling themselves judges. And practically, so did everybody else. They are now routinely referred to as bankruptcy judges. And the National Conference of Referees in Bankruptcy changed its name to the National Conference of Bankruptcy Judges, which is, of course, what it is today. That's why when the National Conference created its own bill and introduced it in Congress, it was known by everybody as the Judge's Bill. So you've now got two bills introduced in Congress, the Commission's bill and the Judge's bill. The House took them up first, and the first thing it did is said, we want one bill to consider. And they basically told the parties, the supporters of the Commission and the bankruptcy judges, you sit down, come up with a compromise so we have one bill to consider adopting. Committee staff, subcommittee staff, talking about the Senate and House subcommittees considering the bills, principal ones were Ken Klee and Rich Levin. As they got into this process of negotiating a single bill, they became convinced that with the broader jurisdiction that's being proposed in this bill, that is now the bankruptcy court can hear fraudulent transfer and preference actions and the debtor's own causes of action, contract, tort actions, and so forth. That with that additional greatly broadened jurisdiction, only an Article III court could handle that jurisdiction. And in your handout, you see what I mean by an Article III court. That is, judges appointed pursuant to Article III of the Constitution, which means appointed by the president for life. That's what an Article III judge is. Any judge appointed any other way is not an Article III judge. You can have what are called Article 1 judges. Article 1 of the Constitution doesn't really talk about judges at all. All Article 1 does is says Congress has various powers. One of those powers is to create uniform laws on the subject of bankruptcies. If in the course of doing that, Congress decides, and we're going to create courts to administer this law, and we're going to appoint judges to those courts, other than lifetime appointees under Article 3, Congress can do that, and they're going to be called Article 1 judges. Nonetheless, Klee and Levin became convinced the broader jurisdiction of the single bill they were putting together could only be done under Article 3 jurisdiction, judges appointed for life. In other words, just like district judges. And that's the change that they then proposed in the House bill. Interestingly, not proposed by the bankruptcy judges themselves, because again, you'd be back to presidential appointments for that process. Nonetheless, that was the single bill that got proposed in the House. We are now a few years into this process. We're now into 1977, when the bills were introduced originally in 1973. During that period of time, both houses of Congress had held numerous hearings. And at many of those hearings, they invited participation by both the bankruptcy judges through the NCBJ, which was actually a player because it's now one of the proponents of one of the bills, and also the Article 3 judiciary. Routinely, however, the Judicial Conference of the United States said, no, we do not care to comment at this time or to send anyone to Congress to testify on the pending legislation. When you've got a single bill ready for approval by both houses, maybe then we'll comment, but not now. Well, what finally changed all that was when the House bill was modified to make the judges Article 3 judges. That got the attention of the Article 3 judiciary. Chief Justice Burger, as president, or chairman, I forget what the official title is, presiding officer of the Judicial Conference of the United States, created an ad hoc committee within the Judicial Conference to respond to the bankruptcy legislation that was pending. And the only response that it had no response on the substance of bankruptcy law. The only response was on the structure of the court. And on that, the ad hoc committee took the position bankruptcy judges should not be either Article 1 judges or Article 3 judges. Instead, we should, in effect, do what we've always done, have referees appointed by the district judges, no independent court of any kind. And in fact, the ad hoc committee wrote that the proposal to make bankruptcy judges judges of any kind, Article 1 or Article 3, was the most drastic change in the federal judicial system ever proposed since the Judiciary Act of 1789. They took it as a very dramatic departure. The first step of the ad hoc committee was to attack the NCBJ in a couple of ways. First of all, they questioned whether their lawyer, who helped and draft the legislation, was an illegal lobbyist. They also attacked NCBJ by saying that by even proposing legislation, they had acted in flagrant disregard of the policy-making role of the Judicial Conference. Bankruptcy Judge Connie Sear responded to this criticism, and he wrote directly to Chief Justice Burger, because he was the ultimate source of this criticism, noting that the bankruptcy judges had sought for 10 years to have some role to play in the drafting of this bankruptcy legislation, either by being allowed to participate in committees of the Judicial Conference or being on the Bankruptcy Commission. and had not only been denied any role, but had specifically been told by Judge Weinfeld, the chair of the Bankruptcy Committee of the Judicial Conference, take your concerns to Congress. So that's what they did. No response was forthcoming from Chief Justice Burger. The only response that did come from the administrative office was addressed, "Dear Sir," and stating only that his letter had been referred to the ad hoc committee, and it similarly never responded. That same week, the Federal Judicial Center, which puts on educational programs for judges, was going to have a seminar for bankruptcy judges and had printed its brochures and materials, and it destroyed them and replaced them with mimeograph materials now entitled "A Seminar for Referees in Bankruptcy." Other things were happening around the country. In San Diego at this time, bankruptcy judges were excluded from use of the judge's cafeteria. In some districts, again in California, both bankruptcy judges and magistrate judges were ordered to wear gray robes, so nobody could confuse them with a real judge. In other districts, the judges' elevators were reprogrammed so they would not stop on the floors where bankruptcy judges held hearings, not judges' elevators. These and similar anecdotes became known to both Ken Klee and Rich Levin, both of whom happened to be California bankruptcy lawyers. Very young ones, I might add. But they, of course, communicated some of this to the subcommittees considering the bills, and they probably were influential in leading to Congress's belief, which became fairly clear, that Congress did not trust how Article III judges treated bankruptcy judges. The Judicial Conference finally said, well, we'll propose our own bill. Although what they did was they took the House bill and made one change to it, but only every time the word bankruptcy judge appeared. They struck out judge and added referee in bankruptcy. The only change made to the House bill. Chief Justice Burger wrote to Ken Klee that a magistrate judge is 3 times as important as a bankruptcy judge, and that elevating referees to judicial status would be like elevating the clerks of court. Well, in the Senate, the bankruptcy bill got assigned to a subcommittee on judicial machinery, one that I'm sure you've never heard of. Probably nobody else had at the time either. A freshman senator from Arizona, of course, gets his committee appointments, and he didn't get very important committee appointments, but he did get this one. So Senator DeConcini from Arizona became the chair of the Senate committee hearing the bankruptcy bill. He introduced a bankruptcy bill very similar to the House bill, which had Article III status for bankruptcy judges, only he substituted an adjunct court of the district court, but with expanded jurisdiction. And now, for the first time, in November of 1977, the Judicial Conference did send a representative to testify at a congressional hearing. Judge Brown, District Judge Brown, started out his testimony, and literally started out, almost his first sentence was, "I will call the bankruptcy judges referees to distinguish them from the judges who are appearing before you today," i.e. the Judicial Conference representatives who were testifying before Congress. And when questioned by subcommittee staff Bob Fiedler whether bankruptcy judges would need their own clerk of court, their own law clerks, and their own court reporters, as distinct from the district court, and remember the bill now pending in the Senate would have the bankruptcy courts as an adjunct of the district court. Well, are they going to need their own clerk of court? Judge Brown responded, "I don't think they need a law clerk. That's why they were appointed in the first place. So he made very clear how the Judicial Conference viewed bankruptcy judges. Again, they were effectively the district court's law clerks. The effect of that testimony on the Senate committee became pretty clear the very next day when NCBJ representatives were testifying, and Senator DeConcini introduced them, and his first comments were, "We have referred to you as judges, and we will continue to do so, and commend the great effort that you do." The Judicial Conference really blew its appearances before Congress from the beginning. All right, another issue is happening, again, perhaps wholly serendipitously, but it feeds into this whole scenario, and that is, since the 1940s, the bankruptcy courts had all had their separate clerks. You had a separate clerk of court to file matters in bankruptcy court throughout the country. But starting in Chicago in about 1962, the Chicago District Court decided to consolidate the bankruptcy clerk's office with the district court clerk's office. In effect, take it over. That idea spread throughout the country so that by 1977, there were 15 districts that had done that. Probably the most important of them, of course, was the largest bankruptcy court in the country, California. Central District of California consolidated the clerk's office in 1973, and for that consolidation, there was no dispute as to why it was done. The bankruptcy clerk's office had two openings where it could appoint additional employees. The district court didn't have any openings, and it needed to get some technical advice. And so it simply consolidated them. That way the district court got control of the employees available to the bankruptcy court. And in addition, it took over bankruptcy court space, or clerk's office space. So it was purely to take control of resources otherwise allocated to the bankruptcy courts. It was done without any consultation with the bankruptcy judges. They were just told, you lost control of your employees. When Chief Bankruptcy Judge Moriarty sought to discuss that with the Chief District Judge, he was even declined an interview or an ability to discuss it. The House bill that had been introduced followed the judge's bill, and actually I think the commission bill as well, and no, not quite. The judge's bill had provided for bankruptcy courts to appoint their own law clerk, their own clerks of court. The Senate bill was unclear. It provided only that the administrative office shall provide bankruptcy judges with necessary staff. Back in 1976, Congressman Edwards, who was also a commission member, had asked then NCBJ President Connie Sear to provide updated figures on how many bankruptcy cases are pending throughout the country, a rather simple survey. Bankruptcy Judge Connie Sear created a survey and sent it out to all of the districts. He got a response, however, from the Eastern District of Michigan, from District Judge Damasio, and Michigan was one of those with a consolidated clerk's office, stating that it would take 7 people working 53 days straight to respond to the survey. And moreover, District Judge Damasio thought it would be inappropriate to do this at governmental expense to provide this information to a private organization, namely NCBJ, which is a private organization, but of course the request for the information had actually come from Congressman Edwards. The next year, when Bankruptcy Judge David Klein was testifying before the Senate subcommittee, he referred to that survey or that response to the survey and noted that all of the independent clerk's offices were able to respond to the survey and do so timely. But the consolidated clerk's offices were apparently so inefficient It would take an employee almost 2 full months of full-time work just to determine how many cases were pending. You can imagine what effect that had on Congress. So in May of 1978, we're getting close to the end of the process of adopting bankruptcy reform, which would include the court structure and the clerk's office. But Senator DeConcini introduced a separate bill providing for independent clerk's offices, entirely separate from the rest of bankruptcy reform. It's not entirely clear why he did that as a separate bill. Maybe it was a fallback in the event bankruptcy reform is not adopted. At least we can make sure that the bankruptcy courts are independent to this level, and that is they have control over their own clerks and their own filings. In any event, a separate bill introduced in May of '78, and then hearings on that bill were scheduled by DeConcini within 1 month of its introduction. Incredibly fast. Congress never moves that fast. It's also unclear exactly why they were scheduled so fast, but one reason may have been, reportedly, that Senator DeConcini had promised Phoenix bankruptcy judge Vince Majori that he would have an opportunity to testify before Congress. And this gave him an opportunity to travel back to Washington and testify, which he did. In addition, Chief Bankruptcy Judge Moriarty, chief of the bankruptcy court in the Central District of California, was invited to testify, which he did. And he testified of the effect of consolidation that had occurred in California 5 years previously. And he basically said what had been an efficient and happy clerk's office was now grossly inefficient with low morale and indeed angry staff, as he described them. Experienced people left, and supervisory layers were added so that you wound up with more staff doing less work and doing it less well. That was his testimony. DeConcini's bill passed the Senate by a voice vote, almost no debate. Again, very quickly after introduction, in the summer of 1978. The ad hoc committee, the Judicial Conference, got word of this. They weren't happy, but on the other hand, they weren't too concerned because they thought this would die for one of two reasons. Number one, we're in the summer of an election year. You know how much work Congress gets done in the fall of an election year. And secondly, bankruptcy reform was coming up. It would deal with the clerk's office. They could address it in that context. And they felt that the House, when it returned from its summer recess, would be consumed with the overall bankruptcy reform. In Los Angeles, however, the district judges were incensed that Chief Judge Moriarty had gone to Congress and testified. They regarded it as insubordination, to put it politely. They held a judges' meeting and voted to strip Chief Judge Moriarty of his status as chief judge. And literally when he got back from lunch that day, presiding was being chiseled off his door. Chief Judge Moriarty happened to know Rich Levin. He let Rich Levin know what happened, and Rich Levin let Congressman Edwards, who again had been one of the bankruptcy commissioners, know what had happened. You can imagine the effect on Congress for someone being punished for having come to testify before Congress at Congress's invitation. They didn't take it well. On the next day, September 8th, DeConcini's bill for a separate clerk's office came up by voice vote and passed in 30 seconds. That's why we have an independent clerk's office today. And by the way, it says that it may not be consolidated with the district court clerk's office except with consent of the bankruptcy court. So they really got control of their own fate. All right, meanwhile, back on bankruptcy reform, Ken Clay and Rich Levin went to work to reach a compromise bill that could pass both houses, and hopefully with unanimous consent, because they knew at this late time, again in an election year, that if you had to go to conference committee, that would take time, and it would give additional time for all of the lobbyists to descend on their own senators and congressmen, which had not really happened yet, except for the people directly involved in bankruptcy. So they worked on coming up with a compromise that could be passed with unanimous consent. In that negotiation, the House finally recognized that Article 3 judgeship status for bankruptcy judges would never get through the Senate. The Senate would not agree to giving the president appointment of 200 new judges. So the ultimate compromise that came out was not truly an independent court, but an adjunct, this time, of the Court of Appeals, but with its own jurisdiction and its own clerk's office and bankruptcy judges appointed by the Court of Appeals for 14-year terms. Chief Justice Burger got word that this compromise bill was about to sail through both houses on unanimous consent without further hearing. He called and literally yelled at Senator DeConcini, accusing him of proposing a bill that was politically motivated and a big waste of money, in Burger's view. He did not get DeConcini to put a hold on the bill, but Burger did call Senator Strom Thurmond and got him to put a hold on it. And then he asked Attorney General Griffin Bell, negotiate a compromise. Use your best judgment, come up with a compromise, and whatever you agree to, you can go forward with, and Thurmond can release his hold on the bill. Griffin Bell did that, and the compromise made bankruptcy courts adjuncts of district courts, but with presidential appointment of judges for 14-year terms. And as to the cost concerns of Chief Justice Burger, and eliminated any retirement provision for bankruptcy judges. In any event, that bill ultimately passed both houses by unanimous consent on October 5 and 6, 1978. After passage, of course, it has to be signed by the president, and in that meantime, and Congress was in session, so if the president doesn't act in 10 days, it's pocket vetoed. So he's got 10 days to sign it. In those 10 days, the White House received 41 communications urging him either to sign or veto. 35 urged him to sign it, and most of those were from creditor constituencies, such as the National Association of Credit Management. Only 6 communications of the total urged a veto, and of those 4 came from Article 3 judges. And one of those was from Chief Justice Burger, urging veto of the entire bankruptcy reform legislation, again, solely because of hostility to the idea of elevating bankruptcy judges to any kind of judgeship status. At the White House, all of the White House staff urged Carter to sign, as did both the House and the Senate conferees and the NCBJ, and ultimately Griffin Bell, who felt, I think, kind of stabbed in the back by Chief Justice Burger. After all, he'd been told to negotiate a compromise and did, and that's the one that got enacted, and then Burger still opposes it. So Bell wasn't too happy with how he'd been treated either, and he urged its signature. Finally, 7 p.m. of the 10th day on which it would have been pocket vetoed, Carter signed the bill. So we got a bankruptcy code. We got a bankruptcy code with, at that time, judges appointed by the president, but not Article 3 judges because they're only appointed for 14-year terms. Maybe the worst of all worlds, right? You get the political process, but you don't get lifetime tenure. Well, that's the structure of the bankruptcy court as the code gets adopted. The next event then is when Marathon files a bankruptcy case, and it has an ordinary breach of contract action against Northern Pipeline, which objects to having its breach of contract action heard by a bankruptcy judge. That, of course, ultimately goes up to the Supreme Court, which held that for an ordinary contract action, that is the exercise of the judicial power of the United States. And Article 3 of the Constitution says, the judicial power of the United States shall be vested in judges appointed by the President for life. Therefore, the Bankruptcy Code is unconstitutional by attempting to vest that judicial power in judges not appointed for life. The primary argument for Congress to be able to do that was what got discussed in the Marathon opinion as so-called the public rights doctrine. A lot of that has to do with when the government is a party. The government can create a court to resolve a dispute in which the government is a party, and it can create that court without appointing judges for life. So again, it can appoint hearing officers to decide claims for Social Security benefits, or it can create a tax court to hear tax disputes. The judges don't have to be appointed for life because it involves a public right. So the question is bankruptcy that kind of a public right? And in addressing that argument, the Supreme Court said, the substantive legal rights at issue in the present action cannot be declared public rights. Appellants argue that a discharge in bankruptcy is indeed a public right, similar to such congressionally created benefits as radio station licenses, pilot licenses, or certificates for common carriers granted by administrative agencies. But the restructuring of debtor-creditor relations, which is at the core of the bankruptcy power, must be distinguished from the adjudication of state-created private rights, such as the right to recover contract damages at issue here. The former, that is, restructuring of debtor-creditor relations that is at the core of the bankruptcy power, the former may well be a public right, but the latter is obviously not. The Supreme Court declared the Bankruptcy Code unconstitutional because it couldn't sever from the entirety of the code this provision for how the judges are appointed and what term they serve for, and then did a very unusual thing. It withheld its mandate, which is the final order that comes out after it issues an opinion, for 2 years, waiting for Congress to act to fix this problem. Because imagine the million cases a year that are being resolved by the bankruptcy courts that have now been declared unconstitutional. Congress didn't get its act together in 2 years. The mandate finally issued. But in the meantime, all of the district courts adopted what was called an emergency rule. Will in effect continue with the old system. We will refer to the existing bankruptcy referees as they were then defined under the law, core bankruptcy matters. But we will hear the non-core matters. Note, by the way, that term core was not well defined and never existed in bankruptcy history before the Supreme Court's Marathon decision. And it just said the restructuring of debtor-creditor relations is at the core of the bankruptcy power. Whatever that core is, not well defined. The problem was finally fixed by BAFJA, the Bankruptcy Amendment and Federal Judgeship Act of 1984, and it effectively adopted the local rule that had been adopted around the country and defined core matters and referred them to bankruptcy judges. Said as to non-core matters like contract actions, the bankruptcy judge could hear them but couldn't determine them, had to issue proposed findings and conclusions of law, would then go up to the district court for the district court to enter final judgment on. But importantly, among the core matters, and I've given you them in the handout, they included, by definition, the bankruptcy remedies of fraudulent transfer and preferences. They were defined to be core. Also, again, I said, under plenary jurisdiction, under the old Bankruptcy Act, that couldn't be tried by the bankruptcy judge absent consent. Unanimously, courts said, well, a creditor consents if you file a proof of claim. That's consent to adjudication of all of your disputes by the bankruptcy court. The BAFJA adopted, in a sense, that rule. We've now discarded the old terms of summary and plenary jurisdiction. But what we did say was, if the estate has a counterclaim against someone who filed a claim, that's core. The counterclaim is core. So if you file a proof of claim, whatever claims the estate might assert against you, whether it's a fraudulent transfer or preference action or anything else, that's core. That can be heard by the bankruptcy judge and determined and enter final judgment. Well, finally, we get to Anna Nicole Smith. You probably don't need a summary of her life and times, but she married an incredibly wealthy and equally incredibly old J. Howard Marshall. And when he died, his will did not provide very much for Anna Nicole at all, even though she was his wife at the time. She claimed, however, that during his life, he attempted to give her many millions of dollars in gifts by creating a trust for her, and that his son, Pierce Marshall, had interfered with that through various nefarious ways, not just trying to convince him not to do it, but actually manipulating documents and so forth. To some extent, she raised those issues in the probate of the will in Texas, although if you think about it, they're not really probate issues at all. Probate is, what do you get under the will? And she's not saying I got anything under the will. She's saying I should have gotten something before he died. And Pierce here interfered with that. There was some litigation going on in Texas, and Pierce got an award of attorney's fees against Anna Nicole Smith. Largely because of that, she filed bankruptcy in California, where she lived. Pierce then, not understanding the distinction between summary and plenary jurisdiction, was dumb enough to file a proof of claim in her bankruptcy case. Back under the days of the Act, any smart lawyer would never do that if you've got any potential counterclaim, right? Which he knew he had. Nonetheless, he did it. She filed a counterclaim. It went to trial, and bankruptcy judge Bufford, after evidentiary hearing, trial, rendered a verdict in her favor of something like $525 million. Largely because of discovery disputes. Pierce was accused of destroying evidence, for example. That went up on appeal. The district court held, no, I don't think this is core. Frankly, I've never understood that ruling because it's a counterclaim against someone who filed a proof of claim. Nonetheless, the district court held it's not core and therefore held de novo review, tried it all over again. It also rendered judgment against Pierce. Only a couple $100 million. Significantly reduced, but still significant. Meanwhile, however, back in Texas, Pierce was apparently still litigating, and he got a judgment from the Texas probate court holding that she had no claims for interference with this intended gift. And the Texas judgment came down after the bankruptcy court judgment in California, but before the district court judgment. And that gave rise to the argument that the Texas court judgment was res judicata, matter decided. And the rule res judicata goes to the court that first decides the issue. That raises the question, was the bankruptcy court judgment a final judgment or not a final judgment? If it was a final judgment, the bankruptcy court resolved it first. If you don't have a final judgment until the district court rules in California, then the Texas court judgment came down first. That's the issue that went to the Supreme Court in Stern v. Marshall. And because by then she goes by Vicki Lynn Marshall. The ruling in Stern then is that a non-Article 3 judge cannot enter final judgment on a counterclaim against someone filing a claim against the estate, at least if it's not necessary to resolving the proof of claim that was filed against the estate. And here the analysis was the two kinds of, the claim and the counterclaim were entirely different. Her claim was, you interfered with my intended gift. His claim was, you defamed me by saying that. And therefore the two are unrelated claims, the court concluded. And therefore an Article 1 court could not enter final judgment on an unrelated counterclaim. For those of you that have had civil procedure, ironically, it was agreed by everybody it was a compulsory counterclaim. So we have a new category of compulsory but unrelated counterclaims, which is ironic because part of the definition of compulsory counterclaims are those that are related. But that's the narrow holding of Stern v. Marshall. And it might be very narrow if it's limited to counterclaims. The rationale, however, might be far broader than that. And where it really is broader is with respect to the fraudulent transfer and preference actions, which, like counterclaims, are similarly defined in the statute as being core, but have now been declared by the Supreme Court as unconstitutional for the bankruptcy court to enter final judgment on. And that brings us to the matter currently pending before the court, executive benefits versus Bellingham. In that action, described by the Ninth Circuit Court of Appeals as being a quotidian fraudulent transfer action. And now you all have to go to the dictionary, because I didn't provide this in the terms of art. What does quotidian mean? I'll leave that to your research. It has no bearing. But in any event, that was about the third word of the Ninth Circuit's opinion. It's a quotidian fraudulent transfer action. The defendant defaulted, didn't answer the complaint, didn't raise, therefore, the issue of Stern v. Marshall until, actually it didn't default, it answered it, it was litigated, but it didn't raise the Stern v. Marshall defense until up on appeal. And therefore the ruling was of the Ninth Circuit, you've waived it. It's a waivable defense. The issue that the Supreme Court is going to decide is it a waivable defense? Most defenses that are personal to the defendant are waivable. Almost all defenses are waivable. But the only defense you can say that's not waivable is jurisdiction, subject matter jurisdiction. Parties cannot, by consent, create subject matter jurisdiction in a court. You can't decide to litigate something here that doesn't belong here. Personal jurisdiction, that's waivable. If you don't assert it, it's gone. So what is this Stern v. Marshall ruling that came out of the Supreme Court? Well, the Supreme's granted cert in Bellingham. And by the way, since then, 3 other circuits have said it's not waivable. Everybody agrees it's not jurisdiction. This is not a jurisdictional question. It's the power of an Article 1 court in a matter where jurisdiction is properly in the federal court system. What's the argument for it not being waivable? You would think that, okay, if you're hauled into federal court, you have a right to have your case heard by a federal judge, and we've defined it what a real federal judge is. It's one appointed for life by the president. That's your right to have your case heard by that kind of a judge. And if you don't assert that defense, haven't you waived it? The argument that it's not waivable is, well, the issue isn't primarily your individual right. The issue is separation of powers, the constitutional structure of the entire government. It's a separation of powers issue. And if it's a separation of powers issue, an individual defendant can't waive that. How is it separation of powers? Well, what this rule does, at least this is the argument that's made, is it prevents Congress from carving matters out from the judicial branch of government and saying, we're taking these kinds of matters and we're deciding them our own way. You can see how that might be a concern of Congress, of the court. For example, back in the days of busing, to achieve integration of schools, there were bills proposed that would strip the courts of jurisdiction over those issues. Not resolve them on the merits, but just say the courts don't have jurisdiction. And you can see how the court, if that's what's proposed, and Congress then says, and we're going to create our own administrative agency, our agency of school busing and anti-discrimination administration, and it'll decide how we integrate schools. You can see how the court might say, wait a minute, Congress can't take a matter that's properly before the judiciary and carve it out and say Congress is going to decide this. And it's going to do it by judges that are political hacks, that don't have lifetime appointment. The interesting question is, well, there's a couple of them, but one is, how is that involved in this case? When you have judges who are not appointed by Congress, they are appointed by courts of appeals. In bankruptcy cases, jurisdiction is before the district court, and at any time, with or without reason, the district court can withdraw the reference, can take any bankruptcy case away from the bankruptcy court anytime it wants to. In fact, that happened in this jurisdiction. The American Continental case, a subsidiary of Lincoln Savings. You all remember Keating and all of that fiasco. American Continental filed bankruptcy primarily to try to keep the Fed from taking over Lincoln Savings and Loan, which of course can't file bankruptcy because it's resolved by, today, the FDIC. American Continental filed bankruptcy. District Judge Bilby, after a few very initial hearings in bankruptcy court, withdrew the reference. He said, I'm hearing this entire bankruptcy case. So how is it that there's a separation of powers concern by the court with a system where the judges are appointed by the judiciary and the Article III judiciary can take any case away from them anytime it wants, to say nothing of the fact that the appeal goes to the Article III judiciary? How does that indicate Congress is encroaching on areas reserved to the judiciary? Well, that's what we are theoretically going to find out. And with that, I think I need to let you go. I'll just mention very quickly the one other issue the Supreme Court decided to hear this term. And that was a gentleman who had a home in California, maybe worth $350,000, at least that's what he claimed, with a $150,000 first mortgage, a $150,000 second mortgage, and a homestead exemption of $75,000. Well, you all know what's going to happen to that case, right? It's going to be abandoned, nothing for the estate. Only the trustee found out that the second mortgage was fraudulent, didn't exist. The debtor made up the person. Lily Lou. She's the one that lent me $150,000 and is the secured creditor. Well, the trustee tracked down Lily Lou and got her to testify, and she said, yeah, he tried to get me involved in this fraudulent scheme. I never lent him a dime. I don't trust him at all. I wasn't going to sign anything. I didn't sign that deed of trust, and I never lent him any money. Well, his argument then was, you got the wrong Lily Lou. The one I was talking about lives in China, and she can't come here to testify because she's had some problem with marijuana, and she can't get in, but that's who I owe the money to. Well, in any event, after all this litigation and all the attorney's fees incurred by the trustee, because the debtor appealed multiple times to the Ninth Circuit, with all of the attorney's fees, where there should have been a substantial benefit available to the estate, there was nothing because of all the litigation cost over this fraudulent mortgage that never existed in the first place. What the court did was surcharged his homestead. Said, we're not going to give you $75,000 out of these proceeds when you cost the estate. The attorney's fees were about $400,000. So when you cost the estate on that, based on absolutely fraudulent claims, you don't get to keep $75,000 as your homestead. That's the other issue the Supreme's granted cert on this term. You might wonder, why is that a national pressing issue in all of bankruptcy law that we need the Supreme Court to resolve? Part of the argument was that the bankruptcy court not only had authority to do what it did under the bankruptcy code, under Section 105, but it also had the inherent power of a court to sanction a fraudulent litigant appearing before the court. The Supreme Court may be about to say, well, that may be true for a court, but it's not true for a bankruptcy court, which maybe, based on our other holding, isn't really a court at all, and never was, although none of you ever knew that before today. But the only other interesting thing I might mention about Stern v. Marshall, even though now it's being argued it was totally a separation of powers decision, and Professor Chemerinsky raised this question: why is it that Stern v. Marshall was a 5-4 decision, and the 5 justices in the majority are all of the conservative justices, the ones who always vote to limit the Constitution, and particularly its protection of individual rights. And the 4 justices in dissent are the 4 liberal justices who are there in all of the individual rights cases to protect individual rights under the Constitution. But now we're saying this isn't an individual rights issue at all. It's separation of powers. Why does separation of powers get decided on that same liberal-conservative split? Did you ever think that was a liberal versus conservative issue? The power of the Article III judiciary vis-a-vis Congress. With that, I'll leave you, and thank you all for your attendance. That concludes the series.